Okay, let's go on to item number 4, discussion and consideration of release of specific executive session minutes. Mr. Park, this is your initiative?
No, Mr. Parks is number 5, Madam Mayor.
No, he
Well-
also brought this up.
Oh, I'm sorry.
I just
My
believe that we should be, at this point in Brookhaven, that we should be looking for reasons to release and not reasons to withhold. Basically, a lot of what I'm hearing in the public is, what else is there? What else do we not know? And I think just in the interest of transparency and open government, unless there is a specific legal reason that we shouldn't release the notes from our executive session where we discuss the release of the Open Records Act, we should make it all public and not hide, not even the perception that we're trying to hide something. We should avoid that. So that is why I made this motion.
I think at the last meeting, we asked for more time because Ms. Jones was new to the council, had not been part of the executive session, and wanted to review the minutes. Have you had a chance to do that?
I have, and I did not mean to cause any delay, but I did not feel in good conscience I could vote on the release of something that I hadn't even looked at. And so I certainly have looked at that now.
So my only concern is really a concern that our clerk raised from her extensive training on handling the records and as it concerns executive session. Could I hear from Madam Clerk on this?
I'm only familiar with the state law that says the executive session minutes shall not be released. But our previous attorney, Mr. Curry, knew of some other law or something within the charter or something. I did not know where he was pulling it from. So I had referred to our new interim city attorney, Mr. Bosch, to review it because evidently the attorney knew of a different law. So I was only practicing from the state law that I had, that I go by. So I defer to the interim city attorney.
So, Mr. Walsh, have you had a chance to look at this?
Briefly, Madam Mayor, I will tell you that I spent a great deal of time yesterday scouring the charter and the city's ethics ordinance, in fact, the entire code of ordinances, for this provision that somehow authorizes council to make public that which would not otherwise be public, and I can't find it. But if we start with the assumption that such an ordinance exists, I think we can answer the question. And you have to start with who's in charge. Under our Constitution, the state is in charge first, and they delegate certain powers and authorities to local government to act on the state's behalf. So when the state creates certain rules, those are the rules that are supreme as it applies to local government law. It's akin to the same rules that apply with the federal government that, since Marbury versus Madison in 1803, that says federal law is the supreme law of the land and everything is subordinate to it. The same rules essentially apply from the state level to local government level. What Ms. Hyatt has said is that the Open Meetings Act authorizes closed executive sessions for 6 reasons. And if you are within those 6 reasons, then the conversation you're having is not part of the public domain. And the minutes that are required under the amendments to the Open Meetings Act are not subject to production under the Open Records Act as a public record. That's the place we have to start. Now, if we assume that the ordinance exists or that there's something in the charter that exists that creates the authority, I think the statute trumps those 2 things. I think the statute says these are not public records. I think there's also good public policy reasons for that being the rule. If we had some council exception or some political exception, if you will, to the Open Meetings Act and the rules that apply to the Open Meetings Act, what you could end up with is a chilling of the ability of council members to talk frankly with each other in executive session. and the business of the people to buy property, to talk about personnel issues, to discuss litigation, sometimes has to be done in private. And the reason the Open Meetings Act exists the way that it does is to limit what those private topics can be and ought to be. So if you're within those 6, then the minutes are not public. That's a very long-winded lawyerly explanation for, I don't think whatever Mr. Curry was talking about trumps the state law that says that this is not a public record and not producible. And the reason that this is now germane is that there's an Open Records Act request pending for these particular executive session minutes. I have not looked at whether or not the topics that were talked about in those executive sessions were properly germane to an executive session, whether they were within the 6 topics that are authorized to be discussed. I've not examined that. Simply, there's not been time in the day to get that done. So we have to start with the premise that if executive session was properly called, and according to the minutes it was for a proper purpose as established and allowed by the Open Meetings Act, according to the minutes that it was, that the topics there were discussed in accordance with that executive session adjournment, and that you then came back out of executive session and back into regular session, and the affidavit of the topics and subject matter of the executive session was attested to by the then mayor. We have to assume at this point that those were all done according to law. If there's some different fact, then that may alter the analysis. But for now, from a legal standpoint, it would be my advice to the council that you do not have the authority as delegated by the state under the charter to alter the state statute, which makes executive session conversations and the minutes of those conversations privileged under state law.
Thank you for that opinion. I think in this case, my default is actually to err on the side of more risk-taking strategy, and that we have, again, as I've mentioned, we have the scrutiny and the trust of the people at hand. If there's an appearance that something's being hidden, let's put it to bed. We have an opportunity to put this stuff out there, and let's do it. The downside risk, I contend, is that the state comes back and says, you shouldn't have done that. You weren't allowed to do that. I really doubt that the state is going to come back to us and say, particularly with such a proponent of open meetings and the sunshine laws as the Attorney General is, that there is going to be any action taken by the state. So for that reason, let's put this stuff out there. Let's put the issues to bed, and let's win back the trust of the people, because this is an issue that can be done once. The law is still the law that we operate under regarding executive session, but this is a perception issue. So I'm fine with those executive session minutes going out.
I find this to be a painfully difficult decision. State law prohibits the release of our executive session minutes, according to our lawyer. That means it's illegal to do it. I don't like that one bit. I'd like to see them released. I don't like the law. But as a lawyer trained in enforcement of law, the fact that I or we don't like the law doesn't mean we can violate it. I'm not even sure that we can legally take a vote about whether to violate state law, frankly. And I am at a loss that this is the state of the law, but frankly, I unfortunately concur with Mr. Balch's opinion, having reviewed that same language of the Open Records Act. It appears that our right to release these executive session minutes is preempted by state law. And I don't know what to say, except I'd like to make my opinion clear that I'd like these executive session minutes to be released, but I cannot and will not vote to violate state law.
Can we direct our city attorney to review the notes, and if there's anything that doesn't qualify under the 6 topics that are not germane to the to the business at hand, that if you find that to be the case, that for that to be released?
Yeah, I think you're going in the right direction, John. I certainly understand your position, Lindley, and I am sensitive to this issue because we do need to respect the letter of the law. You hadn't had, I contend that our city attorney hasn't had very much time to look at this issue. I'd be supportive of putting this thing off till July 7th to allow him time to actually look at this, both on items 4 and 5.
Absolutely.
And actually, Mr. Balch, if you found it, in your legal opinion, to be that these should not have been discussed in the executive session, basically, you are required to release them, correct?
That's my understanding of the law, Councilmember Park. Yes, sir.
Okay, so we don't even need to discuss this again. You can just review it, and if you find that it wasn't germane to what we were supposed to be talking about, you can just go ahead and release it.
Yeah, there'd actually be two things I would have to report to council at that point. We would have to self-report a technical violation of the Open Meetings Act, just to make clear that that may have happened. I don't know whether it's happened or not because I've not looked at the minutes and I don't know what the content of the conversations were. I'd also point out that the Open Records Act that makes this a relevant inquiry is very specific in its scope. And we may end up with two things here. We may have documents or evidence or minutes that ought not be executive session conversations, but are not responsive to the Open Records Act request as stated. So, and I don't have that answer for you either, but I can certainly have that answer by July the 7th.
Was that the correct date, Murray? July
Yes.
7th? Yeah. So do we have an action item?
I mean, there is an action item, Councilmember Madison. I mean,
Pardon me for just a second.
Yes, ma'am, sorry.
Is the audience able to hear Mr. Balch? Okay, I'm sorry. I thought you were saying you couldn't hear. I was going to ask everybody to move a little bit closer to their mics.
Interesting.
It is, you should be informed, Mr. Balch, that we did have an earlier occasion where our city attorney allowed us to release some minutes of executive session concerning a fellow councilman who did end up resigning, but the discussion that was held in closed session on that.
The beautiful thing about being a lawyer is that all of us have opinions.
Don't they?
And as I was explaining to one of the citizens during the recess, if you can't live with the gray area, you don't need to do what we do for a living. So the precedent matters, and I appreciate you letting me know that, Madam Mayor. And I'll certainly communicate with the city manager and make sure I have all of those facts before I make my final report on these questions to the council.
It's been a great conversation. I'm so happy. You know, sometimes it may seem a little embarrassing. We may have had a technical violation of a sunshine rule in executive session. We don't know. If we do, we definitely want to know about it, and we want to self-report. We want to be open. We don't do these things purposefully. This is very, very, very healthy that we have these conversations. I want to thank council.
So, Mr. Balch, you have your second homework assignment.
I do, yes, ma'am, thank you.
Okay. So, item 5.
Madam Mayor, I need to interrupt. I apologize before you get to item 5. Section 2.09 of the charter, specifically subparagraph E, says that in a special called meeting, the only business that can be conducted is that which is in the call.
Oh, that's correct. Okay.
So I wasn't able to answer that question earlier, but I need to interpose and advise the council that the amendment to the agenda does violate the charter, and
So let's not go
Councilmember
there.
Park, I'm not happy to have to make that statement to you. It's not my goal to tell people what they can't do on my first day on the job, but it is my responsibility to advise the council on the lawful order of the meetings and how the charter is to be applied.
That's your job.
Understood. One quick point, though. If you were to go back to the the minutes from the last meeting, I think my motion was to release all emails and executive session notes. But it has to be placed on the agenda. Is that correct?
I'm not sure I understand what your question is.
You know what? Never mind. It's a moot point. We'll put it on the agenda at the next city council meeting.
Yeah, I think his point was that in his motion, it was to, in our last meeting, I guess it was the 16th?
Yes.
That it was basically action item 4, the release of specific executive session meetings and the emails regarding, but as a parliamentary procedure, I thought we had to act on action item things. Do we not have to act? Number 4,
The action items give you the option,
okay. So we don't have
Councilmember
to-
Madison. They're not, there's not a requirement. I think effectively, what I understood the instruction was is that the
Go
council
research
was
it.
tabling the
Yeah.
consideration of number 4 pending my report on July 7.
Right.
If you want to take a vote on that motion to table, I think that would be appropriate. If you want to just give me the instruction and postpone consideration of the action item, that's perfectly lawful under the Meeting Act, under the Open Meetings Act as well.
I think the latter's fine.
One other quick question. This matter is really just a matter of council waiving privilege, attorney-client privilege.
As it applies to the emails?
Yes.
Yes, sir, that's correct.
And so we don't actually need, it doesn't need to be an action item, does it?
Yes, sir, it does.
It does need to be an action
The
item.
privilege belongs to the city as a whole, not to
Okay.
any individual council member or any elected official.
Okay.
So none of you individually have the authority to waive the city's privilege as it relates to attorney-client communications.
Okay.
So to have that, to do that, it is my practice that the council vote in public to say, as to these items, we are voluntarily waiving what would ordinarily be private communications that nobody else gets to know about except us.
Right.
That does two things. One, it makes my insurance carrier very happy, which is the most important one right now. And the second thing is it puts you on record of saying what it is you're telling me to do.
Okay.
And there's no miscommunication between us as to what my mission orders are at that point.
So I would just like to make a statement of that in the interest of openness and transparency, I would encourage all of you to review your emails and even privileged emails between us and our former city attorney. And if it's in the interest of the people to be transparent, I would also encourage you to bring that to light. I found one particular one that was privileged that was not released that I felt that the people had a right to know, considering what happened. So that's just my statement.
All right, with that, I believe we're finished. I'm not aware that we need any executive session, and let me just state for the record that my goal going forward is to have fewer executive sessions. There's certainly legitimate reasons to be able to discuss personnel or real estate or litigation in a closed session, but we've had way too many executive sessions. I think part of it was the protracted litigation with the Pink Pony was some of it, but we will minimize the executive sessions going forward. We will discuss the people's business in open session, in the sunshine, in public, as much as possible. We will err on the side of openness, and so that's my pledge to you as well. So I think we've had a productive morning. Welcome, Mr. Balch. Aren't you excited to be?